Hello, everybody.
Case of, is that Mr. Rapp?
Yes,
We're going to take up the case of people of the state of Michigan versus Jeffrey Robert Rapp. This is file number 24-13741-FH. Appearances, please.
Joanna Carey, Chief Assistant Prosecuting Attorney for the People.
Robert Hartzell for Mr. Rapp, who joins us by Zoom from the Wexford County Jail, Your Honor.
Mr. Rapp, are you able to see and hear us today, sir?
I can see out of one eye.
All right, well, I think that's good enough. All right, so we're here today for a pretrial conference, and that was conducted briefly in chambers between myself and counsel. Counsel informed me that they anticipate today that the defendant will enter a plea pursuant to a pretrial agreement. Is that how we're still proceeding, Mr. Hartel?
It is, sir.
Thank you. Ms. Carey, the terms of that pretrial agreement, please.
Thank you, Your Honor. It's my understanding the defendant will plead guilty to added count 3, use of the controlled substance cocaine, in return the people in counts 1 and 2.
Mr. Hartel, is that a complete and accurate statement of the pretrial agreement?
It is, Your Honor.
Mr. Rapp, I'm told today that you're going to enter a plea pursuant to a pretrial agreement. Is that what you believe you're about to do, sir?
Yes, Your Honor.
Okay, please raise your right hand, sir. Sir, do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Mr. Rapp, as we begin, I need to ask you a couple questions. Turning your attention back to December 7th, 2023, which was about 5 weeks ago, were you on probation or parole to any county or state at that time?
No, sir.
Were you on bond pending any other felony
No,
charges at that? Okay. All right, Mr. Rapp, you are currently charged in this case with 2 offenses. Count 1 is a charge of possession of the controlled substance, cocaine, heroin, or another narcotic less than 25 grams. That is a felony punishable by up to 4 years and or up to $25,000. Now, there's a request to treat you as a second or subsequent drug offender, for which the maximum punishment for that offense could be increased from 4 to 8 years and from $25,000 to $50,000. I'm told that count 1 will be dismissed. Count 2 is an allegation that you were operating the vehicle while under the influence of a controlled substance. That is a misdemeanor punishable by up to 93 days and or a minimum of $100 to a maximum of $500 in fines plus costs, and or up to 360 hours of community service. Plus, you could be ordered to participate in rehabilitative programming. There could be vehicle immobilization and cost of prosecution, as well as reimbursement to the government for any emergency response or expenses for prosecuting you. I'm told that charge will be dismissed. Now, there will be an added count 3 to which I understand you're going to plead guilty. That added count 3 would be a misdemeanor use of cocaine. That is a misdemeanor, again, punishable by up to 1 year and or up to $1,000 plus fines and costs. Additionally, you could be placed upon a period of probation. Is that what you believe you're doing today, sir?
Yes, Your Honor.
Now, by entering a plea of guilty to that added count 3, you will not have a trial of any kind. If your plea is accepted, you will be given up certain rights that you would otherwise have at a trial. Now, that includes the right to be tried by a jury, the right to be tried without a jury if you chose and the prosecutor and court consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at the trial if you chose to testify. Mr. Rapp, do you understand those rights that I just read to you?
Yes, Your Honor.
Do you waive those rights today?
Yeah. Yes, I do.
Additionally, any appeal from the conviction and sentence pursuant to this plea would be by filing an application for leave to appeal. Hold on, I'm just going to let that hissing sound go by. I'm going to repeat that again to ensure that you understood me.
Okay.
I don't know if you heard a hissing sound on your side, but we did. So anyways, any appeal from the conviction sentence pursuant to the plea would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, by pleading guilty may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, if this plea is accepted, you will be given up the claim that the plea was a result of any promises or threats or inducements not disclosed to the court today on the record, or that the plea was not of your own free choice. Mr. Rapp, other than the terms of the pretrial agreement that I went over a few minutes ago, have there been any other promises, threats, or inducements to compel or force you to plead guilty that I haven't heard about?
No, Your Honor.
Are you entering this plea of your own free choice?
Yes, Your Honor.
Now, Mr. Hartel has probably talked to you about potential sentencing, tried to give you an idea or estimate as to why or what he thinks the court may sentence you. My question for you is, sir, has anyone promised or asserted to you exactly what the sentence would be in this case?
No.
Knowing all that, do you still wish to enter the plea of guilty to added count 3 for use of cocaine?
Yes, sir. Yes, Your Honor.
As to that added count, how do you plead?
I plead guilty.
Before the court can accept your guilty plea, it must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to December 7th, 2023 in Slagle Township here in Wexford County. What happened, sir? Did you possess, did you use some cocaine that day?
Yeah, I've been battling with it.
Okay. And so you had some cocaine and you knowingly
I
used it?
didn't have no cocaine. I used it. I had a pipe.
Okay. Well, to use it, you had to have it. Hold on. I'll get us through it. Just trust me. Did you have to use the cocaine, you possessed some cocaine that you knew was actually cocaine? Is that correct?
Well, earlier?
Okay, on or about December 7th of last year, 2020. Okay, hold on, I gotta get the question. Hold on, I gotta get the question out. Did you use some cocaine that you knew was cocaine?
Yes, I did.
All right, there we go. Ms. Carey, do you believe the defendant has provided a factual basis as to added count 3?
I do.
Mr. Hartel?
Yes, sir.
Ms. Carey, are you aware of any other promises, threats, inducements of which I have not heard?
No, sir.
Mr. Hartel?
No, Your Honor.
And Ms. Carey, do you believe the court is in compliance with Michigan Court Rule 6.302?
Yes.
Mr. Hartel?
Yes, sir.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided on the record by the defendant satisfies the elements for the added count as discussed. Therefore, the defendant is found guilty of added count 3, use of cocaine. Now, Mr. Rapp, the case will now be set for sentencing. Sentencing typically takes place on a Monday in the morning. We typically do a sentencing in about 4 weeks after someone is found guilty. Between now and then, the court is going to have the Michigan Department of Corrections, also known as the Probation and Parole Office, prepare a pre-sentence investigation report. Now, this report will include a description of the offense, description of the pretrial agreement, a list of any prior criminal convictions you may have, and it will also make a recommendation as to the sentence. It is strictly a recommendation, as it is the court alone that determines your sentence. Now, there are a couple steps that involve you in the preparation of this report. You will receive a packet of information, and you will complete that packet and return it to the Department of Corrections.
This judge is so thorough. He goes through every single detail like you have absolutely zero clue.
You will also be subject to an interview with that agent. You have the right to have your attorney present at the time of that interview. Each side will receive a copy of this report prior to coming back to court for sentence and have the opportunity to make objections or request corrections to that report prior to the court giving you a sentence. Do you understand, sir?
Yeah, I guess, yeah, yes.
Okay, good. Well, if you don't, you gotta let me know, but basically, you're gonna come back for sentencing. Now, there's a reason why I'm having you come back for sentencing. Could just sentence you today. However, based upon the concept that when I look at this file, I'm concerned about whether or not I want to give you or place you on a period of probation. Now, hold on. Mr. Hartel understands that the court could, or the defendant could ask for, and I didn't talk about this earlier, Mr. Hartel, the defendant has a right to reject probation and ask for a straight jail sentence if it chooses to do so. I didn't talk about that, Mr. Hartel. I'm sure you probably didn't have the chance to talk about it with the defendant. But Mr. Rapp, it's my intent to consider placing you on probation. But if you want just a straight jail sentence, you can ask for that. And if you want that, I can give you that sentence today. I didn't think about that, Mr. Hartel, and I'm sorry, it's my fault that I didn't remind you about it.
Is that gonna be up to the max or?
All right, I can't tell you what I'm going to give you for a sentence because I honestly have no idea.
Okay,
But
well, I like to get, look, I went blind in one eye, and I lost my insurance. I really need to get it, you know, I mean, I messed up. I
Hold on.
relapsed.
Hold on.
Yeah, I'd like to get sentenced today.
Hold on. Mr. Hartel,
Your Honor,
if you would like, let me suggest this. I'm sorry, I was gonna say I didn't mean to cut you off, but clearly I meant to cut you off. Would you like the opportunity to go and speak with him via Zoom so he can make an educated decision on this? And again, as I mentioned, I failed to remind you about that. And I told you during the pretrial that I would probably set it for sentencing, but because I made that statement and then failed to remind you, I want to give you the opportunity to speak with him.
I would greatly appreciate it.
Thank you. Mr. Rapp, you are going to stay right there. We're going to take a brief recess on your case. Mr. Hartel is now going to go to a private room and dial into Zoom. We will place you two into a breakout room. We will then bring you back. Do you
Okay,
understand? All right. Do you understand,
Yes,
sir?
Yes,
All right,
sir.
thank you. We are in recess. Mr. Hartel, come on back. Let's bring in Mr. Rapp. We are recalling the case of People versus Jeffrey Robert Rapp. The attorneys are back and present before the court, and we're just waiting for Mr. Rapp to rejoin us via Zoom, which takes about a minute.
Yeah, 5 seconds.
Takes about 5 seconds. Mr. Rapp now rejoins us. Mr. Rapp, can you see and hear us today still, sir?
Yes, Your Honor.
Thank you. I'm going to turn to Mr. Hartel. Mr. Hartel, why don't you tell me what we're going to do?
Thank you, Your Honor. We do appreciate that extra moment to speak. My client has advised me that he would ask to be sentenced today and waive any right to probation.
Thank you. Mr. Rapp, is that a correct statement from your attorney?
Yes, Your Honor.
All right, thank you. We will go ahead and proceed with sentencing in this case. Ms. Carey, what can you tell me about the defendant's prior criminal history? I can tell here that there must have been a prior drug-related charge that would support the second or subsequent enhancement that I see, and that was a use, in other words, the same offense for which he's pled to today. I don't see any habitual offender enhancements. What can you tell me about his prior criminal history, if any?
Thank you. And he has assault from 1986, possession of marijuana in 1988, attempt R&O in 1989, OWI second in 1995, but I don't have information on the first offense. So sometime before that, he had to have an OWI first.
Okay.
2015 reckless driving, 2019 use, and this year or last year, 2023 harboring misdemeanors.
Can you tell me on the 2019 case, which was the use of a controlled substance, did he hit 7411?
No, it's not on the CCH. I only saw it on his driving record.
Okay, all right, thank you. Your position on sentence, Ms. Carey?
Well, Your Honor, I am gonna ask for, I'm gonna ask for 180 days, given his record, given that he was driving, and again, we don't have, it doesn't appear we have the full maps back yet, but I have, they suspected it to be heroin and fentanyl, which obviously are very dangerous for our community, and I think 180 days is appropriate.
Mr. Hartel?
Thank you, Your Honor. I have talked to my client at length about the situation, and without fully litigating the dismissed cases, I would just say that we are extremely grateful for the plea. We did believe we had some defenses to that, but since those aren't being sentenced, I won't go into all.
All right, no problem.
What I would stress is that my client has advised me that he does wish to be able to go back to his family in Muskegon. He has had some serious health conditions. I don't have any medical records about his ocular situation, but he's advised me that the jail had to transport him to get some medical care while he's there. He feels he can get better medical care on the street. I would ask the court to definitely not go above what the prosecution is recommending. If they were so generous to go to a lower amount, preferably time served, we would appreciate that, but we respect the court's discretion. Thank you.
Thank you. Mr. Rapp, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today, sir?
Your Honor, it was, I had a cocaine problem. I've been trying to battle it, but when I got here, I caught this eye infection and my insurance ran out. And I went blind in the left eye. I didn't, I do got a problem that I'm done with it. Maybe this was a blessing in disguise. But I'm not a bad person.
All right. Thank you, sir. The court notes here from Mr. Rapp that sentencing is not always intended to be, nor is it designed to be, to suggest that you're a bad person. People who struggle with substance use disorder might be great people. They just are struggling with the disease. The court looks here at the defendant's prior criminal history, and it's clear that he's been dealing with some substance use disorder for quite a while. It appears that his substances include alcohol, marijuana, and cocaine, and all of which are operating differently on the defendant's body. But again, it shows the defendant has been struggling with these issues for quite a long time. It's not his first run-in with the law. Additionally, the court looks here that the defendant had a prior conviction for the same substance.
And he can stop self-medicating.
Or the court finds that there are reasonable grounds to give the defendant a jail sentence. Plus, the court looks here that apparently the defendant was pulled over in this event and was operating a vehicle. I'm sorry, Ms. Carey, was his license? Sorry, I don't see a driver's license suspended on here. Was there any issue with his license at the time? Not that he's being sentenced for it, but the court could take that into consideration. No, she shakes her head no. All right, the court sentences the defendant today, and I find my sentence to be proportional. Why? Well, not only based upon the defendant and the event, but looking here at the defendant's prior criminal history, and based upon, while the court doesn't have a set policy, based upon what the court has a traditional record for on uses and some simple possessions of controlled substances, whether or not they are found guilty at the original offense or even probation violations. How long has the defendant been in jail? I needed to get that. It looks like he's been in
51
jail
days.
since
51.
51 days.
Yeah.
I believe that is correct, Your Honor.
Any challenge to that, Ms. Gary?
No, sir.
All right, defendants normally know how long they've been sitting in one spot for a while. I'm sure they count the days. The court sentences the defendant to a $50 state minimum fee, a $75 crime victims' right fund fee, a $150 court cost, a $300 fine, a $150 attorney fee. There are no supervision fees here. The court sentences the defendant to 120 days with 51 days of credit. Mr. Rapp, in case you didn't hear that, because again, I just heard some hissing, the court sentences you to 120 days of jail, for which you have 51 days of credit. Plus, you will of course get the other 20 days of good conduct time credit, which means you're looking at about another 48, 49 days, if I did my math correctly. All right. Anything else, Ms. Carey?
No, sir.
Anything else, Mr. Hartel?
No, thank you, Your Honor.
Mr. Rapp, any questions about what we've done today,
I'm
sir?
gonna have time to pay on that, right?
I'm sorry, you have to repeat that
I'm
again.
gonna have time to pay on that, right?
Well, technically, the answer is it's due today, but obviously I know that you're not gonna pull out a credit card sitting there. The answer is it will be payable and you'll have time to pay. I will make it an agreement. Madam Clerk, can we add that to the judgment?
Okay.
Mr. Rapp, how much per month do you think you can pay?
How much a month?
Yes, sir.
Of, I don't know, $50. I'll probably pay it off quick, but just, at first, just $50
Okay.
or $100.
Yep, the court will order that it be payable at the rate of $50 a month to begin at the date you were released from jail. Okay, sir?
Okay, thank you.
All right, thank you very much. Mr. Rapp, because you're not on probation, if you were to fail to make those payments, the court could bring you in here for a potential contempt charge. Let's hope
Yeah,
that never happens.
But how much is it altogether anyways?
Well, now you're gonna ask me to do math again, sir.
Oh, never mind.
It's gonna be $725.
Okay, Your Honor.
All right. If I get that wrong, please do not tell Mr. Fiddler, who was my junior high math teacher. We are adjourned.
I don't know about you, but he's certainly not the one I love.